Good afternoon, everyone. Thank you for your attendance. We're going to kick off now because we have a fairly packed afternoon. Um, it's great to see so many people joining us from a variety of backgrounds. My name is Caoimhe Gleeson, and I manage the National Office for Human Rights and Equality Policy, who are managing this webinar series, Assisted Decision Making 2015 from Legislation to Practice. Today's webinar is on enduring powers of attorney, the process, and we're joined by a number of speakers from the Decision Support Service, including Anya Flynn, Ian Grehan, Julianne Casey. Professor Sean O'Keefe has also joined us for some additional questions. And then we have a contribution from somebody, Tony O'Connor, who has made his own enduring power of attorney. The questions and answer function is open. Ask questions as the webinar is progressing. And we have a number of questions that were submitted in advance of the webinar, which we will also try to get to. Um, if there are kind of technical issues, please also put that into the chat, and we have a team of people here that will be able to address some of the questions during the webinar itself. The webinar will be recorded. You will be able to access the recording on our YouTube channel, and we will put the link into the chat. You can also access our previous webinars from that channel as well. I'd like to welcome Lisa and Catherine, who are our ISL interpreters. If you wish to have a certificate of attendance, there will be a QR code for you to scan at the end of the webinar, and I'll make an announcement throughout the webinar about that for those that are joining later on. In terms of CPD, we've received 2 CPD points from the RCPI for this event. So without further ado, I'm going to hand you over now to Anya Flynn, who's going to commence today's webinar. Thanks so much.
And thanks very much, Caoimhe, and to the HLC team for the invitation to speak on this today. The purpose of my short presentation before I hand over to colleagues is to really provide an overview and set the scene somewhat about what healthcare professionals in particular, I know that we have other professionals here today, might expect when perhaps directing people towards the EPA process, but also thinking about it themselves. Part of our key messaging and the focus of our current public information campaign is about how EPAs and advanced planning are matters for everybody. So the Act, as we all know, EPAs that we're talking about today are EPAs made under the Assisted Decision Making Capacity Act, an act which commenced just over 3 years ago on the 26th of April 2023. That's an act which, as we know, reforms the law relating to persons who require assistance exercising their decision-making capacity, whether immediately or in the future. And the or in the future bit is what we're focusing on today, that recognition that any of us could at a future point in life lack the ability, the wherewithal to exercise our own right to make decisions, and that's why planning ahead is so important. Every EPA made since the 26th of April 2023 is an EPA made under Part 7 of the 2015 Act. EPAs have been around for a generation, since the Powers of Attorney Act 1996. Since that date, since commencement date, every EPA made is subject to the new procedures. Just reminding us what the Decision Support Service does, and when it comes to enduring powers of attorney, a number of our functions are really to the fore. We have a duty to promote awareness and confidence and to be a source of information and guidance, more on that towards the end. We register and we supervise the performance of enduring powers of attorney, and I'll say how we go about doing that. Our statistics are published monthly, and they have been for quite some time now on the DSS website. These slides, which I think will be distributed, will provide you with various links, but you can link there straight through to where our registration updates are to be found on the website. When it comes to EPAs, it's where we've been busiest. We have registered over 6,500 enduring powers of attorney, about 64% of those in the last 12 months. So that's where we've seen the most significant uptick, and about 300 of those registered enduring powers of attorney have progressed to second stage, meaning that the donor has lost capacity, the attorney has had to tell us, the attorney has then stepped in to take over decision making. And about another 3,000 are with us for review and registration currently, so something like 9,500 in total. Okay, just some of the basics, let's set the scene. There are two ways of planning ahead under this Act, and we're focusing today obviously on one of them. But these are ways whereby a person who has their capacity can create legal instruments to express their will and preferences about their property and affairs and about their personal welfare, appointing trusted decision makers to make these decisions for them, but the instrument only becoming effective in the future if the person lacks capacity to make the decisions covered. The two instruments, of course, being the EPA, the other being the Advanced Healthcare Directive. And from our own survey work, we're not great at this in Ireland. About 100% of people are close to it from our own On the Hoof survey at the National Ploughing Championships last year. We're very interested in the idea of taking up EPAs in particular, but we can see that only about 8% of people actually have one, and it's just a fraction lower when it comes to advanced healthcare directives. So we have a key focus currently on encouraging people to put these arrangements in place. We can't do it by ourselves. We depend on other professionals understanding them and being in a position to promote them also. Because if one doesn't, and this is perhaps one of the frequent misunderstandings which affect people's tendency to make EPAs, you can't rely on your very much in quotes next of kin to step up and do it for you. They have no legal authority so to do. It's an established misapprehension and one that we all need to correct where we can. I mentioned here the results of a survey from some years back, but I think it still is a problem that people believe that my spouse, my partner, my grown-up child, my sibling is simply going to be able to step in legally and take these decisions on my behalf, and not so. That's from our first public information campaign, Helen Rochford Brennan, a very impressive dementia campaigner who spoke passionately about the importance of having planned ahead and the relief that comes with knowing these arrangements are in place. Whilst I'm not talking about advanced healthcare directives today, do know this, that you cannot take care of treatment decisions in an enduring power of attorney. And the separate document then under the Act is the Advanced Healthcare Directive, and here is the template approved form on the DSS website. So some of the terminology then around EPAs, I appreciate that this will be familiar to many of you, but often worth restating the basics. When you make an EPA, you're called a donor. You're appointing a trusted person or persons to act as your attorneys in the future only if and when necessary. So attorney there not signifying lawyer. It is that named trusted person close to you who will step up to this decision-making role. A person, if they have an EPA made prior to the 26th of April 3 years ago under the Powers of Attorney Act 1996, should know that that is still a valid document. There is nothing new that needs to be done with it. The application to bring that into effect, which is called registration under the old Act, is still an application to court. We don't register, we don't supervise in the DSS EPAs made under the prior Act. There's a piece of the 2015 Act which was going to give us the job of putting 1996 Act EPAs on the register. That hasn't commenced. So the two key new features relating to EPAs under the 2015 Act are these. There is a new two-step process. When you make and execute your EPA, you send it to us, the DSS, for registration. That has to happen with every EPA made under the 15 Act. So that first stage is called registration, and second stage, if and should the donor lose capacity, is called notification. You come back to us to notify. Neither of these steps involves a court application, so both steps managed by the DSS. And also new are the supervision and reporting requirements. So an attorney, once they've got to the second stage, they've stepped up, they've become the decision maker, they come under our supervision and oversight. A question that comes up a bit is about the role of solicitors. So to explain, if you want to instruct a solicitor to make and register your EPA, then that's completely fine. Absolutely your prerogative to do so. In fact, the DSS would say if there's a complexity to what you're doing, then it's a very good idea. The solicitor then becomes recorded as your authorised contact. We, as you can see here, have developed separate guidance for legal practitioners who are acting for clients in making and registering EPAs. What we are seeing is that most donors do not instruct a solicitor to make and register their EPA. Over the last 12 months, 95% of donors have not chosen to do so. As you will see from Julianne's presentation in a moment, every EPA submitted does require a legal practitioner statement, and all 9,500 some EPAs that have come our way obviously do include that legal practitioner statement, notwithstanding that a much smaller percentage are getting the solicitor to do the whole thing. I'm happy to take up that point in Q&A if need be. The supervision and reporting requirements. So we've got to the second stage, and this is now true in about 300 of our registered 6,500. The attorney has gone through the process of notifying us, and they have become the authorised decision maker as the donor always intended. So this is new. This didn't happen under the prior Act. They submit reports to us. So within 12 months of the acceptance of notification, they must begin submitting to us annual reports on the performance of their functions, including details of expenses and remuneration, just to allow us that oversight of what's happening. Again, an important safeguard, but we do so with a focus on supporting the supporter, helping the attorney to do a good job. There are template reports available. They're approved by the Minister. If the donor is appointed in relation to property and affairs decisions, then they have an additional earlier obligation to submit to us within 3 months a schedule of assets, liabilities and projections of income and expenditure, and then to continue to keep accounts and financial records and make those available for inspection. Almost all EPAs do include authority in respect of property and affairs. In fact, 98% and rising of EPAs that have come to us for registration are a grant of general authority, allowing the attorney appointed to take on decision making broadly across both property and affairs and personal welfare. So the huge majority will be turning in the 3-month report. If there are problems with reporting, we engage, we try and get things back on track. But if we really can't get reporting to be done correctly, then we can determine that an attorney should no longer act. And we would remove it from the register, and that becomes appealable to the Circuit Court. We can also investigate complaints on these broad grounds about an attorney acting outside of scope, having become unsuitable, acting in some way in breach of function, trying to do what they were never authorised to do, or acting in a way contrary to the Act, including the really important guiding principles about having regard to will and preferences. Significantly, and this is really our only interaction with the 1996 Act, we can take complaints about attorneys appointed under that Act. And early days, certainly the huge majority of our complaints actually were about attorneys appointed under that Act. And in one case, an attorney was removed. No bad faith involved. The particular attorney just had, I think, personal difficulties of their own and wasn't really able to perform the role and didn't really mind being removed. We have the powers, as you see here, about taking up evidence, hearing from people. They could include healthcare professionals to find out what's going on. And the complaint may be raised by any person. I would just caution, think about whether what you intend to do is to bring a formal complaint to us, because we're quite constrained by how we must respond to and process a complaint. If what you really mean, perhaps as somebody working in a service, is I wonder where that attorney has got to, I need to find out about something, if you let us know, we might be able to intervene to get hold of the attorney and get that problem unlocked. If you get onto the complaint path, that is quite a protracted, involved path, ultimately with perhaps a route to court of the person removed. So do think about whether that's your intention in complaining. The codes of practice were published before commencement. There's one for an attorney and other supports available on the DSS website, as you can see here. Various supports and resources. We have a myepa.ie microsite, which I know Julianne will refer to. Also check out advancedplanning.ie, and we have a help desk, living, breathing, humane people who answer calls all day long, about 3,000 a month, and many of them, we answer calls about every aspect of the Act, but a lot of our time is taken up with EPAs, stepping people through the process and providing that interaction as required for both professionals and individuals. We sometimes take the help desk on the road. We've been around the country with that already, with more to follow, so you can find out about that on our news and events on our website. And let me just finish here. This is our latest public information campaign, again trying to promote take up of EPAs, and also encouraging people to think of them not as being about late in life necessarily or when capacity is in question, but something to be done at a time of calm in life, ensuring that that person that you know and trust is authorised, should they need to make decisions for you. And Caoimhe, there, I will leave it, handing over, I think, next to Ian. Ian's going to focus on account setup, the practicalities of getting going with the DSS, and then Julianne is going to walk you more methodically through the various steps of EPA creation and registration. So thank you very much.
So without further ado, I'd like to hand over to Ian. And again, Ian, please speak slowly for our interpreters. And Ian is going to take us through the registration process. So thank you, Ian.
Thank you very much for having me here today. My name is Ian Graham. I'm the head of DSS Operations and Information Services. Today I'm going to briefly cover My DSS, which is the DSS portal, how you open an account with us, and how you verify your identity. Identity verification is an important step of the process so that we know who we are working with, as our service is predominantly digital first. So I'm going to step through the options available for that and how you get through those options. So what will we cover? Digital first, but not digital only. So I'll just briefly talk about our service design and our policy around digital first. I'll talk about where to find the My DSS portal. There's a couple of routes. Most of it is quite self-explanatory. And then finally, I'll just talk about the two separate options for verification of identity. So DSS forms and digital first. So the digital first approach is government policy, but the digital is somewhat written into the Act. There's several sections. Section 79A allows, firstly, the director to specify forms with the consent of the minister, which she has done, and they were signed off and approved. So there are official forms that have to be used for any of our application types, mainly EPA for this particular session. Section 95B, the director may specify that certain documents are in electronic format and the circumstances in which that specification shall or shall not apply. Relevant documents include an application, objection, reports, several different document types that we use. And for the purpose of the register, not crucial to this session, but the director may certify an electronic copy as a true copy. So it means that the certified copy that you have or the certified copy you obtain through the register is certified as a true copy, and that's covered off by the legislation. So the DSS operates a digital first but not digital only approach. The vast majority of our applications happen through our portal, and that is the preference, and that is where we try to encourage and support people to access our application. But there are alternatives available for people who require them. And that's there. You'll see there our DSS accessibility policy, which launched on the 8th of July 2024. That outlines that provides a framework for accessing our paper forms. But the important part there is if someone feels that they're entitled to paper under that policy, for example, if they are unable to use digital technology, or if they are unable to because, for example, they might not have internet connection or they may not have digital technology, then that person just needs to contact us and we go through a short form with them. And really the purpose around that is just to ensure that we're meeting the needs of all people. So for those who genuinely require paper, it can be a lengthier process. So to ensure that digital and paper maintain as close a timeline as possible, we try and ensure that we only provide paper forms to those that genuinely need them. And that provides a parity of service to both those who use our digital applications and those that use our paper applications. So moving on to where to find the DSS portal, you can go to mydss.ie, and that will bring you straight into the portal, and you'll be presented with a screen that I'll show you on the next slide. You can use a search engine. You can search for My DSS. You can search for the DSS portal, Decision Support Service website. Any one of those terms will bring you to the top result will be our portal or our website. If you find yourself on our website, which is decisionsupportservice.ie, you will find in the top right hand corner of the banner, you will see our My DSS login in light blue, and that's consistent across whatever page you are on the portal. So even if you end up down not a rabbit hole, but down a fair bit of reading, you'll always see that up there, and you can always click that, and that'll bring you straight to the portal. And you'll also find it on our microsite. We have an EPA microsite, which is specifically for those that are creating an enduring power of attorney. And when you're on the homepage, there's a couple of tiles there that will give you the kind of journey through an enduring power of attorney application. And just below that, you'll see the box that is on the screen there that says start or continue your journey through My DSS. And that will also bring you into the Decision Support Service My DSS portal. So when you're there, what happens? You'll be presented with that screen that you see on the slide there. You won't see the circles or the arrows, but you'll get that those two different options. You'll see the green bar and you'll see the blue bar. So the green bar is logging in not using a MyGov ID. So you create a login specifically for My DSS. You log your details with us, and then that will give you a basic account, so you get basic access. But if you want to create an application for an EPA, or if you're going to be an attorney or a replacement attorney for an EPA, you must have a fully verified account. So when you go in and you create that account initially, you will see an option in there to verify your account, and that can bring you through that process. It's a short form, and you have to upload a couple of proofs of identity. So you'll also see on this page that just below the green and the blue bars, you'll see this form can be accessed on our website. That little bit of text on the bottom, that will bring you to that manual verification form as well. So again, if you're not using MyGov ID, you can manually verify yourself directly with us. And we often recommend this for this process for people who are using potentially solicitors or other professionals to support them in their application. MyGov ID, however, the blue button there, is by far the easiest and quickest. If you have a fully verified MyGov ID account, you can click into that, enter in your details, and you'll be immediately verified and logged into our portal. So it's best suited to anybody who already has a MyGov ID, someone who might have a PSC card, so a public services card, and that includes a free travel pass. So, free travel pass, you have a public services card. Or if you have a passport and a smartphone, you can also get your fully verified MyGov ID without having to set up an appointment with DSP. So again, all very quick and easy, and you can use that through a multitude of different government services. But again, it's not the only way, although about 76% of people do go down the MyGov ID route, and plenty of people do it directly with us. And the turnaround time, if you do it directly with us, is generally about 2 to 3 days. Sometimes it's quicker, but just to set expectations, it's normally about 2 to 3 days before we will come back to you confirming. And finally, most importantly, if at any point through the login process, account creation, or throughout the application, you need a bit of additional support and you can't find that information on the website or the microsite, give us a bell. We have a contact center that opens from 9 a.m. to 4 p.m. every single day, Monday to Friday. We don't open weekends and we don't open bank holidays. The contact center is operated in-house, so those staff are DSS staff. They're trained and they're very knowledgeable, and they are resourced to be able to spend time with you on the phone, supporting you through an application. So they won't be rushing you off the phone. They're happy to help you through whatever it is that you need. And of course, if phone doesn't suit, you can contact us through any of the methods there. I've got the phone number, which I should have note on this. It's a free phone number, so you won't be charged. Or you can contact us on either of those email addresses. They'll both reach the key teams. And finally, you can contact us on the portal via the queries or feedback buttons that are sitting up in the banner. So as I said, if in doubt, just give us a bell, and the team will be happy to help you out. So that's my presentation for today. I'm going to hand you back to our host, and thank you very much for listening. And happy to answer any questions if anybody has them.
Thank you, Ian. So just a couple of things to say as well. For our next speaker, also watch the speed for our interpreters, and also just to remind everyone that the question and answer function is open. There's been many questions, over 30 questions have already been answered. Some we may answer live, and then there are other questions that have already been submitted. So feel free to use that for any of the questions. I'm going to hand you over now to Julianne, who is the registration manager in the Decision Support Service. Thank you.
Thank you so much, Jacqueline. I'm delighted to be here with you all today to talk about the processes for making an enduring power of attorney. So hopefully now my slides are sharing, so we'll begin. So as Anya had mentioned in her presentation, there is now a two-stage process to enacting an enduring power of attorney. And the first stage is the registration of that enduring power of attorney. This is when the person, the donor, making the enduring power of attorney has capacity and wants to plan ahead for a time where they may be unable to make decisions for themselves. At this stage, the donor chooses what decisions they would like to include in their enduring power of attorney, and they also include the attorney or the attorneys that they would like to appoint in this enduring power of attorney. At this stage, they will be required to execute the arrangement by signing their declarations together. They will also need evidence that they have capacity to make this arrangement. And the Decision Support Service reviews this application and either approves it or provides the donor and the attorneys with further information on why it may not be approved and gives them the opportunity to correct any mistakes that have been made. The second stage then is the notification stage. This happens when the donor no longer has capacity to make one or more than one decisions included in their EPA. The attorneys are then required to notify the Decision Support Service. They do need to provide evidence that the donor no longer has capacity by supplying 2 statements regarding the donor's capacity. And the Decision Support Service then reviews that notification application. Upon approval, the EPA becomes active. The attorney now has legal authority to make the decisions that have been covered in the EPA, and they also become supervised by the DSS and need to provide their reporting obligations. One of the most important things before you start making your enduring power of attorney application is planning for your enduring power of attorney application. And you can see over to the side there that we have developed a checklist called Getting EPA Ready, which is available in these slides, a link to it, and also available on our website. And this outlines all of the questions that you would need to ask yourself before making an enduring power of attorney application. Some of the questions that you need to ask yourself are: what decisions do you want to include in an enduring power of attorney? You can include decisions about personal welfare, decisions about property and affairs, or decisions about both personal welfare and property and affairs. Some other questions that you need to prepare are: what authority do you want to give in your enduring power of attorney? Do you want that to be general authority, which would allow your attorney or attorneys to make all of the decisions that can legally be included in an EPA? Or do you want to give specific authority, where you would need to list out exactly the decisions that you wish for your attorney to have authority to make on your behalf? Another thing you need to ask yourself is if you wish to include gifting in your enduring power of attorney and give your attorneys the authority to make gifts on your behalf to family and friends on customary occasions such as your birthdays or Christmases, or if you want to make donations to charities that you might be expected to make donations to or have previously given donations to. Some other things that you might want to think about are if there are any conditions or exclusions in your enduring power of attorney. For example, some people might have a piece of jewellery that has sentimental value and might want to include a condition to say that that piece of jewellery should not be sold. Another question then that you will want to ask yourself as well is about remuneration. Do you want to pay your attorney a fee for the carrying out of their services as your attorney? And then probably the most important question is who you wish to appoint as an attorney, or how many people you wish to appoint as an attorney. You'll need to ask yourself, how many main attorneys do I wish to appoint? And if you're appointing more than one attorney, how will they make the decisions? Will they make all decisions together jointly? Will they make decisions jointly and severally? Or will they make some decisions jointly and then other decisions jointly and severally? And then another really important question to think about is whether you would like to appoint any replacement attorneys, so that if anything happens to your main attorneys, that your replacement attorneys can come in to act, and that your enduring power of attorney remains an active arrangement. Once you've thought of all these questions and have filled out our Getting EPA Ready checklist, you'll be ready to start your online application. As Ian outlined in his presentation, by having a verified MyDSS account, you'll be able to start your application online through your MyDSS account. When you log on and you have a verified MyDSS account, you'll be met with 6 tiles, and you can click on the Applications tile, which will bring you to the next page where you can start the new application. This will give you the opportunity to select the type of arrangement you wish to create an application for. So if you're creating a co-decision-making agreement, a decision-making assistance agreement, or an enduring power of attorney, you can select the type of arrangement that you need from the drop-down menu. Once you've selected the arrangement, you'll be brought to the Application Steps screen. And this outlines the 5 steps that are required to complete your application and submit it to the enduring power of attorney. Submit it to the Decision Support Service. The first step is completing, generating, and downloading your application form. It's in this first step that you put in your details, the relevant person details. So the donor, or if you're assisting somebody, your client's details, any optional information such as living arrangements or civil status or any communication needs that need to be inputted here. And this information helps us in the Decision Support Service identify any needs or supports in our communication and interactions with you or the applicants. You'll also need to put in your supporter details, so who your attorneys are, and whether you're appointing any replacement attorneys and what authority you are giving your attorneys. You'll need to answer if there's any existing arrangements so that we can be aware if you have an Advanced Healthcare Directive or a 1996 EPA. You'll also need to tell us what decisions you wish to include in the arrangement, if it's the general authority for personal welfare and/or property and affairs, or if it's specific authority, and then listing out the decisions that are required. And then this will bring you to the final step, which is generating the documents. When you get to the Generate the Documents stage, our system will input all of the details that you've previously provided to us and generate the documents that I've listed out here. An arrangement template, which outlines all of the information that you've put into the EPA, a donor declaration, an attorney declaration, a legal practitioner statement, a statement of capacity, and the notice form. We'll now go through the different steps that you need to actually complete the arrangement. So as Anya outlined in her presentation, every application to make an EPA does require a completed legal practitioner statement. A legal practitioner is a practicing solicitor or a practicing barrister. So the donor will need to have this statement completed by a solicitor or barrister who is registered in Ireland at the time they are completing this statement. The donor will need to provide a copy of the enduring power of attorney arrangement template so the legal practitioner can see the arrangement that they're entering into. And they'll also need to provide a copy of the legal practitioner statement to the legal practitioner. The donor and the attorney will need to execute the arrangement. And by executing, we mean signing the donor and attorney declarations. The donor and the attorney, and this is all attorneys, including replacement attorneys, must sign their own declaration together at the same time and in front of the same two people who are known as witnesses. These witnesses must be 18 years of age or older. Neither of the witnesses can be an agent or employee of the attorney, and at least one of the witnesses cannot be an immediate family member of the donor or the attorney. The category of immediate family member is defined in the 2015 Act, and there is information as well on our website and in our guidance material, as well as on the forms themselves of who constitutes an immediate family member. It's very important to note that when the donor and the attorney sign their declarations, there is a statutory requirement of 3 months to submit your application to the DSS from the date that you sign these applications. So for example, if we're signing today on the 18th of May, the person would have until the 17th of August to submit their application to the Decision Support Service. The next statement that's required is a statement of capacity. And it's very important that the statement of capacity is completed after the donor and the attorneys have signed their declarations. This is a legal requirement outlined in the 2015 Act. The donor will need to provide a copy of the enduring power of attorney arrangement document, which outlines the arrangement they're entering into, a copy of the signed declarations, and a copy of the statement of capacity to the person who is completing the statement. The statement of capacity must be a functional assessment of capacity as outlined in the 2015 Act. A statement of capacity can be completed by any registered medical practitioner in Ireland. It can also be completed by a registered nurse, a registered midwife, a registered speech and language therapist, a registered occupational therapist, or a registered social worker. There is guidance material available on the DSS website, which provides a sample template for recording a functional assessment of capacity for the purposes of making an enduring power of attorney. Once all of these documents have been signed, we now come to step 2 of the online application, which is uploading the documents to your online application. The donor will need to log into their MyDSS account and upload a copy of the enduring power of attorney template, a copy of their completed donor declaration form, a copy of their attorney declaration forms, and again, a reminder, one for each attorney appointed, including replacement attorneys, a legal practitioner statement, and the statement of capacity. Once these documents have been uploaded, you'll then progress to step 3, which is where the donor is required to enter in the details of the 2 people who witnessed the donor and the attorney declarations. The donor will need to provide the witness's name, their relationship to the donor, the date that they witnessed the declarations, and their contact details, which can be an email, a postal address, or a phone number. At step 4 then, the donor will need to give notice. So it's a legal requirement that the donor must tell certain people that they are making the enduring power of attorney. The donor must tell all of the following people who are known as mandatory notice parties: the donor's spouse, civil partner or cohabitant, if they have any, the donor's adult children, including stepchildren, if they have any, and any other decision supporter that the donor may have. For example, an attorney under 1996 EPA, a designated healthcare representative, or a co-decision maker. If the donor does not have 3 people from the list above, they must tell an additional 2 other people, who can be friends or other family members. They could also be the witnesses who witness the declarations, or maybe a legal practitioner or a medical assessor. All of these people are called the notice parties, and the donor must give them notice at the same time they submit the application to the DSS. And then we come to the final step, which is pay and submit. At step 5 of the online application, the donor will need to pay the €30 fee and submit your application. We do have fee waivers available for any person who may require a fee waiver and meets the requirements that have been outlined in regulations to have that fee waived. There is information on our website and our guidance materials about this process. Once the donor has submitted the application, they will receive a message from us confirming that we have received the application and will begin our review. Once the application is submitted, we are required to undertake a statutory review, which is outlined in Section 69 of the Assisted Decision-Making Capacity Act 2015, to make sure that the EPA meets all legal requirements. At this stage, there is also a 5-week objection period to allow for any objections to be raised. Objections can be raised by a spouse, civil partner, or cohabitant of the donor, if they have any adult children of the donor, and this includes stepchildren, any decision-making assistant, co-decision maker, decision-making representative, designated healthcare representative, or any other attorney or attorney under the Act of 1996 that the donor has, and any other person specified by the donor as a notice party. It's important to note that objections can also be raised by any person who appears to the director to have sufficient interest or expertise in the welfare of the donor. If any objection is received to the DSS, we will ensure it meets the grounds to object, and where it does, we will review the objections. If an objection is well-founded and upheld, we will inform the donor and attorney of that and refuse to register the EPA. And where an objection is not well-founded, we will proceed to register the EPA. To date, no objections have been found as well-founded. Once the DSS completes its review and notes that all legal requirements have been met, applicants will receive a certified copy of their arrangement, and they can download this from their MyDSS account. This will have the date of registration applied, it will be authenticated with a date and timestamp, and it will be signed with the signature of the director of the DSS. If a donor ever loses capacity and is no longer able to make more than one decision in their EPA, the attorney must notify the Decision Support Service. As part of this notification process, they are required to provide 2 statements regarding the donor's capacity, and these statements can be completed by the same people who completed a statement of capacity in the registration stage. Once again, notice must be given to all mandatory notice parties and all persons who were notified at the registration stage of the EPA. And this time, notice must also be given to the donor. Once an EPA is accepted by the DSS, the attorneys will be able to begin their role and will have the legal authority to make decisions for the donor as outlined in the EPA. They will be supervised by the Decision Support Service and will be required to complete their reporting obligations. We're then moving on to the top tips for making a good EPA. As we all know, errors can cause delays in the processing of applications. And in some cases where the legal requirements have not been met, some documents may require recompletion. So to avoid delays, it's important to consider the following to make sure that you are making a good EPA or a person you're supporting is making a good EPA. One of the best top tips is preparation. To make sure that when completing the EPA, you're using the checklist Getting EPA Ready so that you can ensure that you've thought out of all the questions that you'll be asked in the application. It's very important that you make sure that the document has been executed correctly, to make sure that the donor and all attorneys being appointed have their declarations signed at the same time with the same two witnesses witnessing across all declarations. It's very important to ensure that at least one witness is not an immediate family member of the donor and the attorney. And it's very important that all replacement attorneys, if you are appointing one, sign an attorney declaration, and that all attorneys appointed must sign their own attorney declaration at the same time the donor is signing their donor declaration. Some other things that are very important to note is that the statement of capacity has been completed after the declarations have been signed, that notice requirements have been met, and that the application has been submitted 3 months from the date that the donor and attorneys have signed their declaration. Some other important things to note are making sure that there are no decisions relating to consent to or refusal of healthcare treatment included in the EPA application. And as Anya said, these can only be included in the Advanced Healthcare Directive. If general authority has been selected, it's important to note that you don't need to add additional general decisions which are already covered under the general authority. If specified authority has been selected, it's very important that the donor includes what decisions are to be covered under this specified authority. If exclusions and exemptions and conditions are included, it's important that the donor make sure that these decisions are clear in their instruction and that the attorney understands what was intended by these exclusions and exceptions. Decisions about gifting do have to be specified in an enduring power of attorney, and they are subject to the restrictions under Section 63 of the 2015 Act. And then finally, if remuneration is included for the attorneys, it's important that they make sure that the donor is aware that the attorney is already entitled to reasonable expenses as part of their role, and that remuneration relates to paying for the performance of the attorney's functions. Please make sure that the remuneration that's entered is clear and covers what it is for, when it is to be paid, so if it's annually or weekly or monthly, and how much that remuneration should entail, and whether there's any cap to that remuneration over the lifetime of the EPA, as some of these arrangements may be active for several years. To sum up, we have an EPA information pack to help you if you are making the EPA or to help you assist people in making their EPA. And these are 5 packs included into the pack that detail the journey that I've just outlined here, that go through the general introduction to an EPA, the guide for the donor, which helps them think about what things they wish to include in their EPA, the guide for your attorney so that you can provide a booklet to your attorney so that they understand what their role would entail, a 2-page start the conversation guide to help people start what can sometimes be a difficult conversation, and then finally the practical guide that outlines all of the legal steps as well as includes a checklist for making your enduring power of attorney. All of these booklets are available on our website, myepa.ie, and we do have a QR code there, so if you do want to scan it, it will bring you to the website. And these booklets are all outlined on our website, and you can also download a copy as well if you wish to do so. It will also link you directly to MyDSS so that you can create your application there and then. Some additional resources as well, which may be helpful and which I've already outlined, are the checklist Getting EPA Ready, a practical checklist for completing your application to make sure that you are ticking off and confirming that you've completed the legal requirements. And then I also have an image there of our template for recording a capacity assessment and making a capacity statement for the purposes of making an enduring power of attorney. That concludes my presentation there. Again, a link to our website. Please email us on queries@decision-support-service.ie, and you can telephone us on our free telephone line 01 211 9750. I'll pass back to you. Thank you so much.
Thanks, Julianne, and thank you very much for slowing down your delivery. I think that was probably very helpful for our signers. Just to say, we've many questions in the chat. I think there's over 60 questions have been answered. We've nearly another 30 to be answered in addition to the ones that people had submitted. So there's a question: will these be made available at afterwards? Yes, we'll might have to tidy them up somewhat, but yes, they will be made available. And then the second question was, will the recording and the when will the recording be made available? So we will ensure that the recording, the slides, and the questions will be sent out to participants after the event, so that you're able to access the web link to our YouTube channel. So our final speaker today is Professor Sean O'Keeffe, who will be known to most people on this webinar today. And Sean will talk about some kind of very specific elements. And I know there's many questions, Sean, in relation to the capacity issue. So I think you'll be able to address that in your presentation. Thank you.
Hello, everyone. I'm going to talk about how to complete a capacity assessment and statement for an EPA. As you know, these assessments and statements can be provided by a registered doctor, nurse or midwife, a speech and language therapist, an occupational therapist, or a social worker. And they occur in two contexts. One is when making an enduring power of attorney, and there must be one capacity statement from a qualified healthcare professional that at the time the EPA was executed, the donor has capacity to understand the implications of creating the EPA. And this statement is required so that the EPA can be registered with the Decision Support Service. The second context in which it arises is when notifying an enduring power of attorney. At this time, two capacity statements from healthcare professionals, and it can be the same or different professionals, that in their opinion the donor now lacks capacity in relation to one or more decisions covered by the enduring power of attorney. And this is required to notify the enduring power of attorney to the Decision Support Service. And if the Decision Support Service accepts the notification, then the EPA will come into force. For making an enduring power of attorney, there are a number of statements required, and they include statements from the donor, from a legal professional, a healthcare professional, and from the attorney also. And the statements state different things. And the one that the healthcare professional is commenting on is that the donor had capacity to understand the implications of creating the EPA. The legal professional, in contrast, also has to state that it's not being done as a result of fraud, coercion, or undue pressure. Looking at the wording, at the time the power was executed, the donor had capacity to understand, etc. This has the meaning that the capacity assessment must occur after execution of the EPA. An execution of the EPA means that the EPA has been signed by the donor and attorney and witnessed. And people sometimes say, well, look, I know the person very well, I'm familiar with them, and indeed I recommended that they make the EPA in the first place. It still doesn't matter. The assessment must come after execution of the enduring power of attorney, and the documentation of the assessment and statement must be dated accordingly. And before an assessor can assess, they must be provided with a copy of the actual EPA arrangement document, which notes what powers are within scope of the enduring power of attorney. And they must also have a copy of each of the signed declarations and a copy of the statement of capacity document that they will be required to sign. The other part of the phrasing is that the donor had capacity to understand the implications of creating the EPA. Now, the implications will clearly understand or clearly depend on the scope of a particular EPA, but in general, making an EPA, choosing an attorney, the donor needs to understand that these are their decisions to make. The EPA will only come into force when the donor lacks capacity in relation to one or more decisions. And when the EPA is in force, the donor now can't make those decisions for themselves anymore. Instead, The attorney will make all of the decisions that are in the scope of the EPA on behalf of the donor. This is a powerful position, and it's very important that it's someone the donor trusts to make those decisions on their behalf. It's important also to note that the attorney doesn't have carte blanche to do whatever they want to. They must adhere to the guiding principles of the Assisted Decision-Making Capacity Act, and that includes giving effect to the donor's will and preference and acting at all times for the benefit of the donor, and the donor, while if capacity may vary or revoke the enduring power of attorney. When doing the capacity assessment for making an enduring power of attorney, there's preliminary work to be done, and the DSS provided a very helpful code of practice on supporting decision-making and assessing capacity. But it's important that the assessor explains the nature and purpose of the capacity assessment to the donor, makes it clear that the person has the right to refuse to undergo assessment or to stop the assessment at any stage. And they should also check if communication supports are required and if the person wants a support person present. It's very important, however, that the support person doesn't interfere with the conduct of the assessment. And particularly if the support person is the attorney that's to be chosen, it's important that it's clearly the person themselves understands the implications. And if a support person is interfering with the conduct of the assessment, then the assessor needs to be polite but firm and telling them that must stop. So sort out the ground rules beforehand is best. And finally, the assessor will obtain consent for the assessment. Assessment for making an EPA is again a functional capacity assessment, as all such assessments are under the Act. It's time and decision specific, so the donor needs to understand the implications of creating the EPA, be able to retain that information long enough to make their choice to create the EPA. They need to use and weigh the implications of creating the EPA as part of the process of making their decision. And finally, they must communicate their decision, and in this case, that's by signing or directing that the EPA be signed on their behalf. If satisfied that the donor has capacity to make the EPA, then the assessor will complete the capacity statement form and return it to the donor, who can then upload it on the website. But in addition, the assessor must keep a record of the capacity assessment undertaken, and that includes recording the implications of making that particular EPA and explicitly documenting each of the 4 criteria of the capacity test. And it's good practice in these circumstances to record the donor's own words and responses. The recommendation is to use the record-keeping template provided by the Decision Support Service, and that will ensure that you work through the necessary steps. Now, the record of the assessment isn't required to be sent to the Decision Support Service. However, it may be required later by the Decision Support Service if there is an objection or complaint. For example, with regard to the assessment, is that the donor didn't actually have capacity to make the EPA. And if such a request is received, the assessor must provide the record of the assessment and doesn't need consent or agreement from anybody to do so. The DSS is required by law to undertake an investigation in these circumstances. The capacity assessment for notifying an EPA is slightly different, because before the assessment, you need to again obtain the capacity statement template, but also get a copy of the registered enduring power of attorney from the attorney. And this will clarify what decisions are included in the EPA and need to be assessed. The assessor also needs to query why is the donor's capacity in question regarding these decisions, and this may require seeking additional information if necessary, because the assessor must be satisfied that there is a good reason for the assessment at this stage. And again, one will explain the purpose and nature of the assessment to the donor and the right to refuse or to stop the assessment at any stage, check if there's communication support or a support person needed, and obtain consent for the assessment where practical in these circumstances. For each of the relevant decisions where the donor's capacity is in question, the donor needs to understand the core information relevant to the decision. It's important that information is kept as simple as possible. There's no need for the person to be an expert on the topic. The donor will need to retain the information long enough to make a choice. And remember again, this is not a memory test, and it doesn't matter if the person cannot recall the choice later. They need to use and weigh that information as part of the process of making a decision. And again, remember that people use and weigh information in accordance with their own beliefs and values, and these may not be the same as those of healthcare professionals or of their own attorney. And finally, the need to communicate by whatever means necessary their decision. The outcome now is, if the assessor is satisfied that the donor now lacks capacity, they will complete the capacity statement form and return it to the attorney. Again, they will need to keep a record of capacity assessment in case, for example, there is an objection or complaint to the decision support service that the donor didn't lack capacity to make the decisions. And again, our recommendation is to use the record keeping template for notifying an EPA, and that's provided by the decision support service. There is one question that's cropped up a number of times, and it is people ask along the lines of notifying an enduring power of attorney requires 2 capacity statements, and what happens if the second opinion differs from the first? In the first place, the 2 capacity assessments and statements are independent assessments by qualified professionals, so none is a second opinion. If, following assessment, in the assessor's opinion, the donor doesn't lack capacity, well then the assessor will decline to complete the capacity statement. And again, they'll keep their own record of the assessment, but this won't be requested by the decision support service. And if there is only one completed capacity statement, then the attorney will not be able to notify the decision support service, and the enduring power of attorney cannot come into force at this time. But there's nothing further for the capacity assessor to do. He or she doesn't have to discuss or debate the outcome with the other assessor, doesn't have to arrange for a further assessment, and doesn't have to expect to interact with the decision support service regarding their assessment. So remember, if you're doing an assessment, it is independent, and you do it in good faith to the best of your ability. Thank you very much for your attention.
Thank you to Sean. And just a couple of things to reiterate again. There's a question about CPD points. There's going to be a QR code at the end that you can take a photograph of, and that'll bring you. I think that's correct. I'll just check that in a moment. And then the second thing is just to reiterate that the information made available today will be sent to participants. So that includes the link to the YouTube, where the recording is going to be held, the slides, and also the questions that people have asked. So our last speaker is interviewed by Jacqueline. Tony O'Connor was interviewed by Jacqueline, who speaks about the making of, he's actually made his own EPA. So I'm going to hand over to Jacqueline now, and then afterwards then we will take questions. Thank you.
Hi, Tony. Thank you so much for taking the time to talk to me today about your experience of putting in place an enduring power of attorney. So can I just ask, first of all, why did you decide to put an enduring power of attorney in place?
Well, I was always aware of it over a period of years, and I suppose what actually finally made up my mind was one day I was having a drink with 2 very good friends, and they both happened to mention that they had done just that, and that they had made powers of attorney, but one of them in particular had a very good reason, because his wife was unwell. And what left an impact was the fact that when I asked them how much it cost, one said it cost 1,800, and the other told me it was 1,400. So I resolved to make a power of attorney, but not by paying 1,800 quid. And I was aware vaguely that was a system in place through the assistant decision-making side of government that allow you to do it yourself. Thus, I resolved to go ahead, and that was the main thing. My 2 friends assured me it was really difficult to do it online. They had that made me all the more resolved to do it online. So off I went. And actually, it was not half as bad as it came.
And in terms then, obviously, you have to get your legal statements and your medical statements as well. How did you go about organising them?
In regard to the lawyer, I then decided that, well, it said in the documentation it could be a solicitor or it could be indeed a barrister. It so happened, as it turned out, that a very good friend of ours is a barrister, and she comes to the house, and so we simply asked her to sign. But the real function of the barrister or the lawyer is, of course, to advise the person about the legal implications of what they're doing. And I think by the time most people have entered into this, they will be aware of the fact that they're handing over rights over their what to do with their property and with important aspects of their lives to a third party. And consequently, it behoves them to be fully aware of the implications of it, that the function of the lawyer is to simply remind you of that. And the same goes for the doctor. We went to my family doctor, whom I've known for many, many years. But in practice, for example, my wife went to the doctor. It wasn't her normal doctor, and therefore the more appropriate avenue applied. That is that she actually said, okay, and charged her for it. I think it was a fee of 80 quid. That is not covered, even though you may have free GP.
Yeah.
It's a separate fee. But her reaction was to go to her computer and to read out the official questions.
So how did you feel doing the whole process of putting in place the enduring power of attorney?
I was entirely pragmatic about it, and so was my wife, actually, because, well, it's a simple fact as you get old. I'm in my mid-80s, and as you get older, you become very, very aware of the fact that all around you, people are losing the ability to make decisions. And friends and colleagues and relations, of whom we have many, but a lot of them have died now. A lot of them, some of them, more than I would wish, have lost the power to make decisions that are important. We've appointed 2 attorneys. By the way, I think that it's important to have 2 because one may, God forbid, not live as long as you do. Secondly, the other question is, by the way, for example, we have 3 adult children, but one lives in America, so that would not be an appropriate choice. So the 2 that live in Ireland, preferably close by in Dublin in our case, it makes sense to have them at hand. And if you have a good relationship with them, and you're so lucky in that regard, well, it's an easy choice.
Yeah.
So I would advise you to appoint 2 attorneys.
But what advice would you give someone who's thinking about putting an enduring power of attorney in place?
Well, number 1, obviously, is to find themselves a suitable person, preferably 2 suitable people. That's easily the most important. And let them know what's required. Of them. It's not just tokenism. By the way, they should be very, very careful. They have very strict rules about getting signatures. We used our very, very excellent neighbours as witnesses, so that was very easy. But if you have 2 attorneys, for example, both of them must be there on the same day and signing in front of the same witnesses.
Yeah.
Can't have a second attorney separately somewhere in a pub signing or anywhere else, but in front of the same witnesses. When I had 1 or 2 questions, I phoned up the decision-making people. They were beyond helpful, and it could not have been easier. So I would strongly counsel people to take it on. It may seem intimidating at the start, it really isn't. And we've now done, or I know of quite a few having been done without any trouble.
Thank you so much, Tony, for that. I really appreciate your time this morning.
Super. Thank you very much to Tony for taking the time to talk us through that as well, and for Jacqueline to interview. If I can get our panel just to switch your cameras back on, and we will, in the remaining 20 minutes that we have, we'll try and tackle some of the questions. I just want to note the work of our panelists and my team as well, who've been flat out literally answering questions. We're nearly at the 100 mark, which is, I think, a record for this team. So anyway, without further ado, I'm going to start with a question, and it's probably for both Sean and Anya, just maybe to start us off. So there's a question about if somebody lacks capacity for finances, but doesn't lack capacity in other domains, in their enduring power of attorney, is there a way, like, does everything kick in with an enduring power of attorney? Let's say they put a whole load of decisions in there. Like, is there a way it's gradated or not? Is it like a full switch or a part switch, I think is the question.
I think we've only seen, well, to be clear, as I think I said, 98% or more of the EPAs that have been registered with us, I think Julianne can confirm, have been general authority EPAs. So the donor has said, in the event that I lack capacity, I'm appointing this person to decide everything. Now, I suppose the capacity statement that is taken up at the second stage, the notification could be nuanced. It could say still fine in respect of X, but now lacks capacity in respect of Y.
Yes.
I suppose there's potential for that, Sean might have a view, but we just haven't seen that. So of the 300 EPAs that have gone from being registered to being notified and the attorney has stepped up, they haven't been broken down in that way. There hasn't been a sort of a targeted capacity assessment, but there's potential for that. I think, yeah, the attorney's functions to notify us commence when they, I think it's have reason to believe that the attorney now lacks capacity in relation to some or all of the decisions covered. So it could be specific in nature. We haven't seen that yet.
And can an assessor, so this question has come in from an assessor, can an assessor make that clear in their assessment, and maybe write to you to say, I believe that, say, Sean lacks capacity in relation to his finances, but he does not lack capacity in relation to the other things that are other matters that are specified in his EPA. Is it okay for an assessor to do that?
Yeah, we can object to it if we think about the key principles of the Act and the least interventionist approach. It shouldn't be that, well, I have no choice but to say they lack capacity in relation to everything. That wouldn't be real. It's just not something that we've seen. We haven't experienced that as yet. I think I'm correct. Yeah. Julianne is nodding that we haven't seen anything dealt with in that way. But Sean might have a view.
Yeah, Sean, it'd be helpful to have your view on that.
Yeah, I think you can and should in those circumstances. Now, fortunately, a lot of times it is general authority, but there is a lack of capacity in the different domains, but sometimes there may not be. And of course, you just have to have regard to what's actually in the scope of the statement when you're doing the assessment. But the assessment is on the decisions for which capacity is in question. So that can arise. It does help that, remember, even if an attorney is in place who should be somebody trusted by the person, they do have to give effect to will and preference if ascertainable. So it shouldn't actually make a real difference on the ground, in that if the person still has clear views about personal welfare and the real problem is in property and affairs, then there shouldn't actually be a practical problem. But yes, I agree with Anya.
Okay, super. Anya, we have quite a few questions in terms of difficulties in accessing a solicitor. So what do you advise in relation to that?
Okay, solicitors can be involved in two ways. Either you may prefer to ask a solicitor to do everything for you, to make and to register the EPA. And as I said, about 5% of intending donors over the last 12 months have taken that approach, gone to solicitors and asked them to do everything to create the document. And we engage with solicitors every day who are doing that. They become the point of contact. Our interaction is with them, and we've developed separate resources for practitioners who are doing that. All EPAs require the legal practitioner statement. All 9,500, some EPAs that have come our way have a legal practitioner statement. But if any intending donor is experiencing that element as a blocker to getting their EPA made, we would urge them to contact the DSS so that we can point them towards a practitioner who may be able to help. So I would urge that doesn't become a problem, and that people are still able to make their EPA. Please contact us.
Okay. So moving on then, how do I know if someone has an EPA under the 1996 Act or the 2015 Act?
I think that one came up in the chat as well, and I answered it. These are registered. You can't make an EPA under the 2015 Act other than by coming to the DSS. You have to send them to us. They have to be reviewed by us, registered by us, and then they're on a searchable register, which would reflect also whether it has moved to second stage and been notified and the attorney has begun to act. We have no such function at all to register 1996 Act EPAs, they still take their validity. They are triggered by being registered in court. You go through the Office of Wards of Court to do that, and we're not involved.
Okay. And next question, Sean and Anya might take this one. Can a healthcare professional or a medical doctor who's related to the donor, who's not their professional practitioner, can they complete the capacity statement?
No, under
limited by the reg. Yeah, I think I answered that one in the chat as well. So that's limited by the regulation which defines who those healthcare professionals are, and then states don't do it if you are a close family member, and close family member is defined.
Okay. Right, I'm going to go to the live questions now as well, just some of the ones that weren't answered. So can you clarify what does jointly and severally mean, Anya?
Okay, jointly is always acting as a unit. So if you've appointed A and B jointly, A and B, A can't act independently of B. If you've appointed A and B jointly and severally, then A and B can act independently of each other. Often more convenient than trying always to have the gets together. It might be more practical to have jointly and severally, or you may specifically only want A and B acting as a unit. So do think about that.
Okay, who can be a notice party if the spouse and child are attorneys?
Right. Well, the attorney has to be a notice party anyway. So the trick is, and I think Julianne dealt with it, feel free to come in, Julianne, if by the time you get to the end of that list of people who are mandatory notice parties and you only have one, am I right, Julianne? Then you need to have another two of your choosing who could be professionals, further out relations, people that you want to know about your EPA. Have I got that right, Julianne? Yeah.
Yeah, that's correct. Yeah, so just say if I have 3 mandatory notice parties because I have 3 children, and all 3 of those mandatory notice parties are also my attorneys, you don't need to give notice to anyone else because those 3 mandatory notice parties, as being appointed as your attorneys, have been given notice. So it would only be in the case where you have less than 3 mandatory notice parties. So if your spouse and child are your attorneys, and then you have 2 more children who aren't part of the arrangement, you would have 4 notice parties. So it's only where you have less than 3 mandatory notice parties that you must give notice to 2 other people.
Okay. So this is a question for Sean and Anya. Why do you need 2 capacity statements to register, I think it is, or to activate or to notify here enduring power of attorney?
The law says so.
We didn't write the act, anybody here present. So everything that we do is statutory in nature, and that's a requirement under the act. It did get slightly finessed when the act was amended in 22. So I think it used to read that at least one of them had to be a medic, I think. And now you still need 2, but either can be a medical or another healthcare professional.
Okay. What do you mean by gifting? What does gifting mean in the context of EPAs?
Giving stuff away for nothing back. It doesn't have any more kind of highfalutin meaning than that. And the rules on gifting, as Julianne said, are quite strict. So that you do need to specify that your attorney is going to be able to make gifts, otherwise they can't. And those gifts are restricted to kind of the ordinary customary gifts or charitable donations. Julianne, I haven't left anything out there, have I? Is that it? Yeah. Yeah. Again, all of it's spelled out in our guidance.
Okay.
Yeah.
Okay. Another question on the oh my sorry, this my screen keeps jumping on notification. If you've 7 children, all adults, do they all have to be notified? If you've got, so that's one question, and then related to it, you've got a number of children that you're no longer speaking to, do they have to be notified?
Julianne, do you want to take the first part about mandatory notice parties, and I'll speak about discretion then?
Yes, so all notice parties do need to be given notice at both the registration and the notification stage. So even if you have 7 adult children, all 7 adult children do need to be notified. Or in some cases, you might have had 5 adult children when you were registering the EPA, and now when you're notifying it, 2 of those adult children have now become adults. So it would be then up to the 7. So yeah, that's one of the requirements.
And what sometimes comes up, Caoimhe, and I think the questioner is alluding to this, is what if you can't get hold of, have no relationship with 3 of your 7 adult children? There is a discretion which we are rarely actually asked to exercise. I think it's under section 69(1)(b), is it?
Yeah.
Where if you have made reasonable efforts to satisfy the notice requirements, then you can ask the director to treat them as being satisfied. But actually, I think in probably fewer than 10, maybe fewer than 5 occasions have we been asked to exercise that discretion.
Yeah,
And
that's
just
correct.
another question, just related to that, if there's safeguarding concerns about one or two of the notice parties, is there any discretion there, or do they have to be notified?
Yeah, that was one of the, without getting into too much detail, that was the kind of the fact situation that arose in one case where we exercised discretion, yeah. Where we were able to say, well, reasonable efforts were made in all of the circumstances, and therefore you don't have to, at the registration point, go ahead and notify those. There were like a clear supportive evidence of an active safeguarding problem.
Thank you. Question for Sean and Anya as well. So just to make the distinction again, I know you referred to it already, but just again, what is the distinction between a capacity assessment and the capacity statement, Sean?
Yeah, the assessment is the process whereby you sit down with the person and interview them, and you do your preparation, you do the assessment, and the statement is where you document the outcome. If it's for creation, if the outcome is that you agree the person has capacity to make it, and for notification, if you agree that the person lacks capacity to make it. So, assessment is the base. The statement documents the outcome. Thank you.
Okay. And Anya, could you say something about the importance of the assessment itself in case there's questions further on down the line?
Yeah, good to have a record of it. We don't ask, as Sean has said, we don't ask to see your notes and records, but there's a template for recording how you did it. And there's only one way that the capacity statement can look. So, don't improvise. There is, it's a mandated form that you're completing. They haven't materialized as, the source of any kind of argument very often afterwards, hardly at all, thinking about it. Because, again, looking at you, Julianne, we don't really get many objections to registration in. One of the objections to registration can be, no, the donor doesn't have capacity. How is this even happening? That rarely crosses our desk as a ground of objection. But as Sean has already said, should that happen, we would be trying to find out a bit more about how capacity was assessed. It could be, again, arguably a later ground of complaint. How did this get over the line? The donor didn't have capacity. And then we may need to do a retrospective and see how the statement was obtained. It just doesn't happen very often. But that's, I suppose, why you would want to keep your records. But we aren't by any means interrogating medical and healthcare professionals all the time about how they possibly concluded that somebody did or didn't have capacity. That's just not what we see.
Yeah,
Okay.
objections are raised in about less than 1% of applications submitted to us.
Okay.
Yeah, and to date, none have been found as well-founded and upheld.
Yeah, and the grounds could, well, they're a bit more likely to say that's not a suitable attorney. I think capacity doesn't have to be the grounds on which objections are raised, and yeah, it's just not a phenomenon.
Okay, so there's a couple of questions now in terms of who. So if you want to appoint a professional person as an attorney because you don't have a family member or a friend that you can ask, can you do this, and how you can go about that? And then related to that one is again, person doesn't have somebody, can an NGO who's supporting that person, can they apply to become their attorney? So two questions there.
Okay, take the last one first. You don't apply to be somebody's attorney, somebody applies to appoint you. And that would be kind of the preparation piece. Who do I know? Who do I trust? Who, importantly, is prepared to do it? Because the attorney has those obligations, reporting and being under our supervision at the later stage. So it's something for anybody to think about before they say yes to the role and sign statements saying that they know what they're getting into. So, and then if you don't have somebody close to you, well, an attorney doesn't have to be a relative by blood at all. It's the person that you know and trust. That's the significance of the relationship. So pick whom you know, who you're going to rely on, appoint them to do what you want them to do, make sure that they know what they're getting into, and all should be well. You can appoint a friend, you could appoint a professional if you want. And possibly have to remunerate them for it if that's what you want to do. So there's nothing.
And on that question, would that need to be provided for in the enduring part in the instrument itself? That
if you're going to remunerate, you have to say that you're remunerating somebody. Yeah. There's no authority to pay yourself or pay anybody else as an attorney unless that's provided for in the document.
Okay. Okay. So do the attorneys have to be resident in Ireland?
No.
Okay. Okay. I'm sorry, I'm just trying to fly through the very last one and then I'm going to try and sum up. No, I think we've kind of most things covered at this point. So I just want to in the kind of remaining time that we have, I think Jacqueline, has the QR code been shared in the chat so that people are able to get access to that for their certificate of attendance purposes. I just want to just reiterate again that all of this information will be made available to participants after the webinar. I want to thank our panelists, Sean O'Keefe, Anya Flynn, Julianne Casey, Ian Grehan, and Tony, and Jacqueline, and Catherine, and I can't see our other sign language attorney, Lisa, as well, for their help, and also to my own team who've been working in the background trying to answer all of the questions, and of course to Tom for his technical support today. I suppose just to say there was huge interest in this webinar. It's a very technical webinar. I think a lot of the questions are quite technical, which is why I think people need to have access to the information afterwards to be able to familiarize themselves. I would encourage everyone on the call to use the resources that Julianne and Ian and Anya have talked about. There's an enormous amount of information available online for people, and with videos and support information that I'd encourage you to come back to a number of times as well to familiarize yourself with the process. If there's any questions that we haven't addressed, we'll follow up with these afterwards with the team here, and we'll try and get the information out as quickly as possible. Just to say, this is a series of webinars. We're just planning our next one. It may be in June, it may be in early July, but we'll revert back to people as soon as possible in relation to that. So without further ado, that's us at 3:30. Thank you all for your time, and thanks all to the team today. Goodbye now.
Thank you.
Thank you all.